Today, on this episode of Law Weekly, the chairman of the body of benchers reaffirms the need for integrity at the bar while presiding over the call to bar ceremony of over 4,500 applicants. The president of the Nigerian Bar Association boycotts the event as he insists on the recusal of the chairman of the body of benchers. We also have highlights from the inauguration of new executives of the Arbitration Committee of the International Law Association. Plus, Justice Rita Ofili-Ajumogobia returns to the bench, as well as other top trending stories in the news. Hello and welcome to the program. I'm Shola Shuyeli. The week began with a letter dated Sunday, December the 4th, written by the NBA President, Senior Advocate of Nigeria, Yakubu Mekiel, to the chairman of the body of benchers, Senior Advocate of Nigeria, Chief Wole Olanipekun, asking him to step aside and not preside over the call to bar ceremony of the Nigerian Law School scheduled for Tuesday, December 6th and Wednesday the 7th. The 10-page letter had the title, A Call to Salvage the Image, Reputation and Integrity of the Body of Benchers and the Legal Profession, and for the call to bar ceremony to be presided over by Honorable Justice Mary Peter Odili, the Vice Chairman, Body of Benchers. In the letter, the NBA president noted that the body of benchers since its establishment has some of the best legal minds the nation has ever produced, personalities with impeccable character. The letter goes on to reference the negative impact of the email of Ms. Adekunbi Ogunde, a former partner in the law firm of Wole Olanipekun & Co. In the email sent to Reaffirm, an expatriate company, which was involved in an ongoing $130 million case at the Rivers State High Court, brought against them by the Rivers State government, Ogunde had claimed that her principal, Chief Olanipekun, was capable of significantly switching things in favor of Reaffirm. She specifically said, Chief Olanipekun is currently the chairman of the body of benchers, which is the highest ruling body in the Nigerian legal profession, made up of Supreme Court judges, presiding justices of the Court of Appeal and chief judges of all state high courts, including the Rivers State High Court. In other words, Chief Olanipekun is the head of the entire legal profession in Nigeria. Mr. Mekiel acknowledged that the law firm of Wole Olanipekun & Co. has been excused from any liability regarding the email in issue, but went on to say that the public reactions that trailed the emergence of that email and the decision exonerating the law firm gives a bit of insight into how the body of benchers is presently being viewed by some members of the profession and the Nigerian public. Tracing some of the reactions, he emphasized that a collective action of the body is absolutely necessary and imperative in letting Nigerians know that the members of the body are not who the email says they are, and at the very minimum, the chairman, Chief Wole Olanipekun, ought to recuse himself, if only to show some respect for what the body stands for. He concluded that given the need for an urgent remedial action, he adopts the letter by his immediate predecessor in office, Oluwapata, calling for its immediate consideration by the body of benchers. He also called on the chairman to immediately yield to the vice chairman of the body, Honorable Justice Mary Peter Odili, to preside over the call to bar ceremonies. The letter was copied to the Chief Justice of Nigeria, Justice Olukayode Ariwoola, and to all benchers. Now, the body of benchers, which has not made any public comments on the matter in the past, had an already scheduled meeting the very next day, Monday, December the 5th. The statutory meeting was not open to the public or the press, and its agenda was to deliberate and approve the report of the screening committee of the body for the call to bar ceremony of qualified applicants. Law Weekly learnt that the NBA President, Senior Advocate of Nigeria, Yakubu Mekiel, tabled the issue for discussion at the meeting. Members were said to have engaged in robust and sometimes heated discussions, with some arguing that the letter was not on the agenda. Others argued that the issues were weighty and they would need to have copies of the president's letter so as to consider those issues properly. Many members also noted that the NBA president's letter was only written on Sunday, December the 4th, and they had not seen the letter nor been served copies of same. The secretary of the body of benchers was also said to have admitted that the NBA president's letter was only received by the secretariat at 9:30 a.m. on the morning of the scheduled meeting. Some of the members who spoke off record to Law Weekly said the chairman of the body of benchers, Chief Wole Olanipekun, had however insisted that the matter be discussed because his integrity was at stake. Two former Chief Justices of Nigeria, Justice Mahmood Mohammed and Walter Onoge, who contributed to the discussions, asked that proper procedure be followed. They maintained that the meeting was a statutory one to deliberate on and approve the report of the screening committee of the body of benchers for the call to bar ceremony of qualified applicants. In the end, the majority decision was to defer the discussions on the issue to the next meeting of the body, which is scheduled to hold sometime in January 2023. Chief Olanipekun's tenure as chairman body of benchers is expected to come to an end in March 2023. Now, reactions have not stopped trailing the issue, and a few lawyers shared their thoughts on the issue.
I feel the president has every right to alter the letter. Now, recalling that before the changing of administration, wherein we had Mr. Olumide Akpata as the NBA president, Mr. Akpata had written to the body of benchers, also making the same demands as to the stepping aside of Chief Wole Olanipekun, Senior Advocate of Nigeria. Apparently, that did not happen. Is the NBA president right? In his capacity as the NBA president, he has the mandate of members of the bar to act, and he should act responsibly. What he has done in the capacity as the NBA president, it's definitely right. I think that if at all Chief Olanipekun, Senior Advocate of Nigeria, would not step aside, there should at least have been a point in time when that issue would have been discussed. But having no response, more or less like a silence, a deafening silence on this would definitely makes everyone who are members of the Nigerian bar to wonder what is going on. Why are we having this situation? And there are plethora of questions with regards to this.
I can say that I find it quite unsettling that the national president of the Nigerian Bar Association would boycott the call to bar ceremonies because, first of all, one must first consider whether or not the national president is an important component to the call itself. Unfortunately not, because this responsibility falls on the body of benchers, which is the highest body in the legal profession. So I would think that the NBA president was unfortunately misdirected or ill-advised to have boycotted such an important occasion, especially since the new wigs were coming into the profession. They were supposed to be received by the Nigerian Bar Association, which is the only bar recognized in our country. Now, for the reasons why he boycotted, again, it was very relevant because these issues have been discussed and has been relatively trashed out. So it really made no sense, but rather was an embarrassment to the rest of us who are legal practitioners that the president of the Nigerian Bar Association, who is looked on as the representative of all lawyers, was absent from such a call for such a reason.
On Tuesday, November 6th, the president of the bar issued another statement declining to participate in the call to bar ceremony. The statement reads in part, "I am in good conscience unable to attend and participate in the call to bar ceremony. The NBA under my leadership cannot be part of the ceremony superintended by the current chairman of the body of benchers for all the reasons stated in my letter under reference. To do so will be to endorse, celebrate, or condone a practice that I consider unwholesome and unprofessional by virtue of the Rules of Professional Conduct for Legal Practitioners, 2007. The NBA under my leadership remains committed to the protection of the integrity of the bench and the bar and will not shirk that responsibility."
Good afternoon, ladies and gentlemen, and welcome to the second.
Despite his absence, the call to bar ceremony went on as scheduled. The ceremony began with the procession of the body of benchers into the Hirat Ade Balogun Auditorium, where over 4,500 applicants waited to participate in the event. The event was widely attended by members of the bench and the bar. The Chief Justice of Nigeria, Justice Olukayode Ariwola, past justices of the Supreme Court, justices of other courts, as well as some senior advocates of Nigeria are present. The Director General of the Nigerian Law School then presents the successful applicants to the body for their call ceremony.
The distinguished chairman of body of benchers, sir, distinguished members of body of benchers, may I now present to you the aspirants here assembled this afternoon for call to the Nigerian bar. They wish to and are eligible to become members of the learned and noble profession of law. They have successfully completed the vocational training at the Nigerian Law School as prescribed by the Legal Education Act. They have all taken the prescribed examinations as well as the dining terms and met all the required conditions set by the Council of Legal Education. I am happy to affirm that they all exhibited good manners and decorum during their training. They have also been groomed in the ethics and ethos of our own noble profession, together with other academic and non-academic members of staff of the Nigerian Law School. I've closely monitored these aspirants during their training, and I've watched for each and every one of them as men and women of learning and character, as demanded by your august body. The screening committee of your distinguished body has carefully perused the records of each and every aspirant and found them worthy to be presented for call to the Nigerian bar. I attest that they are fit and proper persons for call and admission to the Nigerian bar. Mr. Chairman, may I respectfully and in my own honor present to the distinguished body of benchers the following 4,711 from the total of least qualified applicants for call to the bar at this ceremony. Thank you for the privilege and God bless.
After the applicants have been presented, all 4,711 of them are called to the bar by the chairman of the body of benchers.
By the powers conferred on the body of benchers, by Section 3 Section 1 of the Legal Practitioners Act, and by the powers conferred on me as chairman of the body of benchers by Regulation 16 of the body of benchers Regulation 1983. I hereby admit each and every one of the applicants standing here this afternoon, present all of you severally to the bar as barristers and solicitors of the Supreme Court of Nigeria. You may now put on your wigs.
He goes on to caution the new wigs to desist from any act that would bring shame to the profession.
It behoves me at this point to forthrightly prepare your minds for the inevitability of bumpy rides. Aspersions, tirades, general vicissitudes, and such other contingencies to which all humans are susceptible. These eventualities are of universal character, sparing no one, irrespective of illustriousness, nobility, pedigree, tribal or ethnic affiliations, religious inclinations, affluence, eminence, or dexterity. Yours faithfully is, of course, a living example. Our profession boasts and parades three key words: noble, honorable, and learned. Covet these flagship words in your endeavors, undertakings, and relationship with others. Act nobly in and out of court. Behave honorably in all your dealings with your colleagues and clients, as well as with the bench, for those of you who will end up in legal practice and those who will end up on the bench. Do not engage in strife blackmail, mudslinging, campaign of calumny, treachery, or any attempt to run or pull anyone down.
He also warns the National Assembly against giving effect to its proposal to regulate the establishment of law schools in the country.
May we plead with the National Assembly to stop toying with the idea of promulgating laws or amending the Legal Practitioners Act to pave way for the proliferation of law school campuses, particularly around in their neighborhoods. It is within the exclusive prerogative of the Council of Legal Education, in consultation with the body of benchers, to establish new law school campuses. While else, do not question the jurisdiction of the National Assembly to make laws as appropriate. Law school campuses cannot be established without clearance from the Council of Legal Education. What we need now is improvement and upgrading of the existing law school campuses. Using the newly commissioned Graham Douglas Law School Campus, Port Harcourt, built and equipped by the Rivers State government as a model, I dare say that it is the best in the country for now.
And here is what he had to say on the issue of remuneration of both judges and lawyers.
It is not realistic for any council, whatever might be the newness or greenness of his or her wig, to be paid any wage equivalent to what the government terms minimum wage of 30,000 per month. Without being immodest, a UCOM member posted to any law office deserves more than that as a supplementary allowance. When we have to take care of these ones, I plead with members of the body of benchers. Let us put heads together. It is our profession. If any of these ones suffers, it is collective suffering for all of us.
Welcome back. The Arbitration Committee of the International Law Association wants more professionals to collaborate with individuals and key stakeholders in the legal sector to improve the efficiency of arbitration in Nigeria and on the African continent. These, they say, will encourage a swifter resolution of more commercial disputes. The leadership of the committee made the call at a ceremony held at the International Arbitration Court in Lagos to inaugurate the new executives of the Arbitration Committee.
This is the 2022 International Arbitration Conference and inauguration of new excos of the Arbitration Committee of the International Law Association, ILA. The hybrid event with the theme Recent Trends and Opportunities in International Commercial Arbitration attracted key players in the legal and arbitration fields with over 900 virtual attendees. Participants first listened to goodwill messages from some of the key stakeholders here.
Our committee is discussing today, it's very important, contemporary issues in international commercial arbitration. And I'm sure that Mr. Notvaivo will do great justice to that topic in her keynote. But also, those of you who are here, as well as those who are online, you should feel very much free to participate and to make it as interactive as possible. And once again, I welcome all of you, and I add my own welcome to the expressions of welcome already expressed.
The keynote speaker is the immediate past chairperson of the Arbitration Committee, Mrs. Adedoyin Rhodes-Viver. She makes a case for more Nigerians and Africans to rise to the opportunities presented by arbitration for swifter resolution of disputes.
Now we have an enlarged community. We have more sensitivity to diversity and inclusion concerns. We have proliferation of arbitration institutions. We have more modern practices and evolution of enhanced standards and procedural innovations for the continued efficiency and effectiveness of international arbitration. And enhanced standards for all our practitioners in the field. We now have the IBA guidelines on countries of interest. We have the IBA rules on taking of evidence in international arbitration. So many instruments, so many soft laws in this age of autonomy. So I think the time has come to enlarge the scope of the Africa Promise. When you see African arbitrators, you see their numbers rise in any type of arbitration from any type of hemisphere, because that's what it is the other way around. There's some conferences I've seen they're having, and when you look at the speakers, there might be Africans, but they're all Africans based in the diaspora. That's not what we're aiming for. We're aiming for a level playing field. So those are all the things we should try and fight for, but not ask for it to be handed to us on a platter of gold. We have to work for it. We have to show we are competent. We have to show we can do it.
After answering questions on some of the available opportunities and more, then came the high point of the conference as she moves on to inaugurate and decorate the new exco under the leadership of the chairman, Dr. Tolulokpe Aderemi. The new chairman, Dr. Tolu Aderemi, in his inaugural speech, dwells on his plans to promote the resolution of commercial disputes with minimal discomfort to parties and much more.
In a judicial system where the wheels of justice grind so slowly, one would have expected that arbitration practitioners will be the advocates, both in action and in words, for alternative dispute resolution to settle their clients' commercial disputes. If indeed the intention is to encourage the resolution of more commercial disputes, are we achieving this feat? We must all work together. And I therefore enjoin you to commit to supporting the association, either by becoming a member, sponsoring any of our trainings, or collaborating with us to provide training and mentorship to your colleagues at your various institutions. In the coming days, months, and years, my committee pledges its unwavering determination to advance the cause of arbitration in Nigeria. I look forward to the days ahead with optimism of a revived market.
The national president of the ILA also gives some suggestions on what the new exco should focus on.
The first is training. The second is capacity building, although training also fits into that. And the third is ethics, very important. Most of the challenges that the speakers referred to can all be traced back to these three: lack of training, lack of capacity, lack of ethics. So if people understand very well what arbitration is intended to do, they will forge less documents, they will impede the process less, the judges and the courts will provide a more supportive role, and so on.
The new leadership of the Arbitration Committee says it's poised to increase on the gains of the past leadership, and this should no doubt translate to better times ahead for arbitration practitioners locally and globally.
And just before we go, let's quickly do a recap of some of the top trending stories from the courtrooms.
We begin with the report that the Supreme Court of Nigeria has dismissed an insinuation that the Chief Justice of Nigeria, Justice Olukayode Ariwoola, was subjected to interrogation by the Department of State Service over alleged pro-Wike political remarks. The Apex Court also debunked claims that 5 justices of the court demanded the resignation of the CJN over the same issue. In a statement by the Director of Information and Press of the court, Dr. Festus Akonde, the Apex Court warned those peddling the rumors to desist in their own interests. We proceed to the Federal High Court, where the National Judicial Council has reinstated Justice Rita Ofili Ajumogobia as a judge of the court. The reinstatement takes immediate effect. A circular of the Federal High Court dated December the 5th was signed by Chief Judge of the Federal High Court, Justice John Soho, notifying all judges of the court of this decision. He wrote, "Your Lordship are by the circular letter notified that at the meeting of the National Judicial Council held on the 1st of December 2022, the Council reinstated the Honorable Justice Rita Ofili Ajumogobia as a judicial officer." In Lagos, the Federal High Court sitting refused the bail application of the Kogi State House of Assembly candidate of the New Nigeria People's Party for Ankwa 2 constituency, Mr. Ismail Atumei, and 2 others. The trio were arraigned before the court on an 18-count charge of alleged 1.4 billion naira bank fraud. The 2 are a former employee of Union Bank, Abdulmalik Salau, and one Ngene Joshua. The court noted that the magnitude of the offense is such that the defendants can interfere with the law enforcement procedure and run away. Also, the court noted that extradition procedures from anywhere is such a cumbersome process. We'll close with the reports that the First Lady, Aisha Buhari, has withdrawn her case against a final year student of the Federal University Dutse Aminu Adamu. Adamu, 24, was arrested by the police in Dutse for allegedly publishing a defamatory statement on his Twitter handle against the First Lady. In the alleged tweet, Adamu, who is studying environmental management, posted a picture of the First Lady with a caption in Hausa saying, "Mama is feeding fat on poor people's money." The tweet was posted on June 8, 2022. Withdrawing the case against the accused on Friday, the prosecution counsel, Fidelis Obobes, said the First Lady, as the mother of the nation, decided to withdraw the case following the intervention of well-meaning Nigerians.
And that's the program for today. If you missed any part of it, you can find it on past episodes on our YouTube channel. Don't also forget to give us feedback via any of our social media platforms. I am Shola Sheli. Thank you for watching and see you next week.